Okay, this is cause number M331-315, case of South State of Texas versus Sergo Cadet. Mr. Cadet is present in court. Mr. Cadet is represented by Marjorie Munez. Attorney Munez is not here. Standing in for Attorney Munez is Attorney Dustin Galmore. And Mr. Galmore, what is your announcement in Mr. Cadet's case?
Judge, we are asking for more time to pay the fine in this case. However, I have an idea that just popped in my mind, which can be dangerous. If he were to enter his plea today, what would happen is the judgment would be printed and he'd be
Or
required
give
to
him time to pay it?
go downstairs. But what we could do is reset for sentencing in 60 days. And that way, he's already done the judgment, he's already done the fingerprints. And if we get the fine paid and get it returned to the court.
Well, what we
return-
what we can do, actually, we can do it today. And I can, we can give him time to pay off the
There you go.
fine and court costs.
And he wouldn't need to be here to pay.
He wouldn't, no, he just have to get it here. Of course, if he doesn't show up, then we can do a capers pro fine.
Right.
Right.
That sound better? We'll do it today. You'll send the money to me and I'll go pay it for you. Sounds good. Let's do that, Judge. I think it's
Okay.
best.
All right,
I'll sign it up.
okay.
Look back on the door.
Keep him on the document. Giovanni Estrada Hernandez. Oh, Mr. Gilmore. Gibbs County Court Order number 2 is back in session and quoted in session. 2 cases, cause numbers 25 CCCR 0344 and cause number 25 CCCR 0345. Both cases are styled of State of Texas versus Giovanni Estrada Hernandez. Mr. Hernandez, is that your full name? Mr. Hernandez, would you please raise your right hand? Mr. Hernandez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Hernandez, you may put your hand down. How are you doing, Mr. Hernandez? I'm doing fine. Thanks for asking. Mr. Hernandez, the state is represented in these cases by Attorney Shane Hilton. Thank you, Mr. Hilton. How are you doing?
I'm good, Your Honor. Thank you.
That's good. Ms. Redmond,
Yes.
could you hand me the 2 documents that I printed? Should be is that judge's explanation and a waiver? Mr. Hernandez, did I swear you in? Okay, now, Mr. Hernandez, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to waive your right to attorney and represent yourself? I also have another document that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? Is this your signature on the line that's titled Defendant? Now, Mr. Hernandez, before you signed and initialed both of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Hernandez, I also have before me on my computer a document that is titled misdemeanor plea admonishment. Well, I'm gonna go to the first document. I have a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. Now, before we go any further, Mr. Hernandez, you have a right to have a court reporter to type down everything that's being said in this proceeding, or you have a right to waive, which means to give up your right to have a court reporter to type down everything that's being said. Do you waive or give up your right? You waive? Okay. Now, Mr. Hernandez, in this document that is titled information, it alleges that you, Giovanni Estrada Hernandez, on or about December 15th of 2024, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of duty of striking a fixture or highway landscape. Do you understand what you've been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Mr. Hernandez, I also have before me on my tablet a document that is titled misdemeanor plea admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document?
Yes, sir.
On page 2 of the same document, there are a set of initials on a line next to a box that's checked Nola Contendere, which means no. Oh, he didn't, there's one spot he missed.
Yes, sir. I just thought of that.
Okay. Now, Mr. Hernandez, I also have before me a document. On this document, page 2 of the State's Exhibit number 1, there are 2 sets of initials. First set of initials is the lower paragraph that's titled waiver, and the initials are on the line next to a box that's checked guilty. Did you place your initials in this location? The second location of the initials is below a paragraph that is titled discovery admonishment, and it is on the line next to a statement that reads as follows: I do not wish discovery in this case. I do not wish discovery of evidence. I waive my right to discovery of the evidence in this case and choose to enter a plea of guilty or no contest. Did you place your initials down here on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next, that's the same one. On the next document, he didn't sign this one either. That's the trial court certification. Okay, now this next document is titled Discovery Certification. And do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Hernandez, before you signed and initialed all of these documents that I just showed you, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Sure.
Mr. Hernandez, are you a citizen of the United States? State?
State offers State's Exhibit number 1, Your Honor.
Mr. Hernandez, the state is offering State's Exhibit Hmm. Something happened to this doc. Could you, the document, I don't. Did you get it back? Did it go back to you?
That's it.
Oh, there you go. Okay. Hmm. Oh, you're gonna have to initial these again because it just erased what you had did. You gotta sign both of those documents. Okay, now, Mr. Hernandez. Before you sign and initial these documents, you read the documents? You understand what you read? Is everything in these documents true and correct to the best of your knowledge? And you are a citizen of the United States, is that correct?
Yes.
And state you offer states exhibit number 1, is that correct?
Yes, Your Honor.
Now, Mr. Hernandez, the state is offering states exhibit number 1 to be used as evidence against you in your case. States exhibit number 1 is the first document on this tablet that you acknowledge. This is the same document that have your initials in these 2 locations, and it has your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objection. State's exhibit number 1 will be admitted. Mr. Hernandez, is there any evidence that you are currently mentally incompetent to stand trial? Mr. Hernandez, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is the agreement?
Your Honor, we would ask the court for 12 months of deferred adjudication with a fine of $250, repayment of court costs, 40 hours of community service, and restitution in the amount of $717.13 payable to the complaining witness Kirk Gillespie. And then in exchange for a plea on this cause, the state will move to dismiss the companion case 25 CCCR 0345.
You said that's Kirk Gillespie, huh?
Yes, Your Honor.
And the restitution is 717.13.
Yes, Your Honor.
Yes.
What is, oh,
3:30.
3:30, okay. Yeah, just give him 60-day reset. It is, but he got 60 days to pay it.
Okay. It's still a form to go. It shouldn't be, yeah, it's still a form.
Okay.
Okay.
Okay, Mr. Hernandez, the state is offering that you pay, well, that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $250. You'll also be required to pay court costs of $330, probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and restitution in the amount of $717.13 to Kirk Gillespie. Your total monthly installments, that is the total amount that you will be required to pay each month, is $201 a month. Will you be able to pay the $201 each month?
Yes, sir.
You will also be required to perform 40 hours of community service. And you would be required to adhere to the other standard terms of condition of this probation. The state will be dismissing cause number 25 CCCR 0345. Mr. Hernandez, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer?
Great.
Okay, Mr. Hernandez, I'll follow the people are in agreement that you have entered into with the state. Mr. Hernandez, please have a seat in that first chair on the wall. Wait for your name to be called. You're gonna follow the directions of the bailiff. Just have a seat. Where is the bailiff? Jefferson County Code Law number 2 is back in session. The court is in session. Calls number M331315. Cases filed in the state of Texas versus Sergo Cadet. Mr. Cadet, is that your full name? Mr. Cadet, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? You may put your hand down. How are you doing, Mr. Cadet? You doing all right? That's good. I'm doing fine. Now, Mr. Cadet, you're represented in your case by attorney Marjorie Muniz. Ms. Muniz is not present. However, standing in for Ms. Muniz is attorney Dustin Galmore. Does Mr. Galmore have your permission to stand in for Ms. Nunez? You have your permission? Okay. And Mr. Galmore, how are you doing?
Living the dream, Judge.
Okay. Now, Mr. Galmore, do you waive a record in Mr. Cadet's case?
We do.
Mr. Cadet, I have before me a complaint that was filed by the, let's see, Beaumont Police Department. Yeah, this complaint was filed by the city of Beaumont. In this complaint, it alleges that you, Sergo Cadet, on or about March 23rd of 2021, while you were in Beaumont, Jefferson County, Texas, that you committed the Class C misdemeanor offense of making unsafe pass or passing unsafely. Do you understand what you have been charged with?
I know, he's asking if you understand that you were charged with unsafe lane change. Okay.
You understand that? And to this charge, how do you plead? Guilty, not guilty, or no contest? No contest. Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges? Now, Mr. Cadet, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Do you recognize this document? On page 2 of this same document, Mr. Cadet, hold on a minute. Okay, on page 2 of this same document, Mr. Cadet, I have before me, there's a set of initials on a line next to boxes, Chetnola Contendere, which means no contest. The initials are SC. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yeah.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that?
Yes.
The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that? And Mr. Cadet, I need to go back to State's Exhibit number 1. And I need to insert a word, complaint. And I inserted this word complaint because you're charged by complaint, not by information. Do you understand that? All right. I also have a document that is titled Discovery Certif, no, I have the number. A document that's titled Discovery Certification. You recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
Now, Mr. Cadet, before you signed and initialed these documents, did you read the documents? Or did your attorney go over these documents with you? And did you understand everything that he went over? And is everything in these documents true and correct to the best of your knowledge?
Yes.
And Mr. Cadet, are you a citizen of the United States?
That offers State's Exhibit 1.
Any objections?
No objections.
No objections. State's Exhibit number 1 will be admitted. This one now has case number. The case number. No objection states exhibit number 1 will be admitted. Mr. Galmore, you advised and counseled Mr. Cadet. Is there any evidence that he is mentally incompetent to stand trial?
No, Your Honor.
Mr. Cadet, your attorney, Mr. Galmore, has advised and counseled you. Are you satisfied with his representation? And Mr. Cadet, your attorney, Ms. Munez, has advised and counseled you. Are you satisfied with her representation? Okay. Mr. Cadet, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have any plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for a fine of $100 and repayment of the court costs.
Okay. Mr. Cadet, the state is offering that you pay a fine of $100 plus court costs of 300 and, what was that court cost? 380? It was 277?
We're thinking this.
Okay,
That's what's on there. Okay, what's the-
hold on a minute.
So. I'm having-
Okay, Mr. Cadet, your fine is, state is offering a fine of $100 plus court costs of $277, which comes to a total of $377. And, let's see, you're unable to pay that today, is that correct? Okay, so what we'll do, we'll reset this, well, we'll put it on a payment plan. No, the plan is for him to pay it in one installment. Give us a 60-day reset. Okay, this payment will be made by July 7th of 2025. And we'll set it for compliance here. If that payment is made before that date, you will not have to be here on the 7th. Okay? So Now, do you understand the state's offer? You think the state's offer in your case is fair and just? And do you accept the state's offer?
Yeah.
Okay, now, Mr. Cadet, I'll follow the people who are in agreement that you have entered into with the state. Now, Mr. Cadet, if that payment is not made and if you don't show up, you weren't going to be issued for your arrest for a capious profane. Okay? All right. So, Mr. Cadet, just have a seat and wait for your name to be called. Once your name is called, you'll go and follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go and you have a blessed day. Just have a seat. All right. There you go.
Hold on. That's just a reset. He needs to stay. Yeah.
They wait on anything else?
Absolutely not. I'm just waiting. I'm just- Andrew's the only person
Yeah.
for some reason. Like mine won't pull anything.
The charts behind me.
What you hand me one, two, I need one.
Thank you.
Thank you.
Seating chart anymore, or they're not accurate anymore?
What you mean?
Are the seating charts, we have seating charts, and are they accurate?
What you mean? You talking about this here?
Yeah.
Yeah.
Okay. Are they accurate?
What you mean are they accurate?
Yeah, that's like.
Okay, so I'll just write that here.
Yeah.
Wait. Dr. Crowley is wrong. I don't know. They're usually up closer.
He gotta be printed? He hadn't been, make sure he does not leave. He has not been printed by you. Okay.
Yeah, if there's one missing, no kid, no. One, yeah, we know what we're gonna get to, all 13.
Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court this afternoon to serve as a juror in a criminal case. The criminal case that we have is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanor. Your felony cases are referred to as your most serious type of offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can get if they are convicted of the offense. Now, felony cases are divided in 5 categories. Misdemeanor cases are divided into 3 categories. Your felony cases, the 5 categories, we'll start at the top. You have the capital murder, first degree felony, second degree felony, third degree felony, and the state jail felony. The person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. If a person is convicted of a third degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second degree felony, the range of punishment is minimum 2 years to a maximum of 20 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a first degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony offense, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, we do not handle those type cases. We handle misdemeanor cases. Misdemeanor cases are divided into 3 categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanor, if a person is convicted of the Class C misdemeanor, the range of punishment is by fine only. The fine cannot exceed $500. Now, if a person is convicted of a Class B misdemeanor, the range of punishment is minimum 0 days to maximum 180 days in the county jail, or a fine that does not exceed $2,000, or you could be given both such fine and confinement. Now, if a person is convicted of the highest misdemeanor, which is a Class A misdemeanor, the range of punishment is minimum 0 days to maximum 365 days, which is a year in the county jail, and or a fine that does not exceed $4,000, or the person could be given both such fine and confinement. Now, as I mentioned to you earlier, you have been asked to come to court this afternoon for a misdemeanor criminal case. Now, our courtroom hours are normally from 9 a.m. to 5 p.m., but usually in the morning at 9 a.m. we have other dockets. That is, we have business going on in the courtroom, and we usually don't get to the trial docket until 1:30. That's when we pick the jury. Now, we started our trial docket at 9 a.m. this morning, along with our announcement docket and our pretrial conference docket. And then those dockets ended close to 12. And so now we're starting our jury trial docket. And whether or not you're selected as a juror in this case or not, you are performing a significant duty which only free people can perform. The case will be tried expeditiously, consistent with justice, which requires a careful and correct trial. If selected on this jury, unless otherwise instructed, you'll be permitted to separate for recess, for meals, and at night. Now, I must administer to you the first of 2 oaths. So at this time, I need each and every one of you to raise your right hand, and when I finish and administer the oath, please say I do. Everyone, please raise your right hand. Do you, and each of you, do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions touching your service and qualifications as a juror, so help you God. Please say I do. Okay, you may put your hands down. Now, the law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain exclusions and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service in a criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you have been seated on the jury, the case could be retried and you may be held in contempt of court and placed in jail for up to 180 days and fined up to $500. Now, the way I'm going to ask the questions, I'm going to ask a series of questions. I do not want you to answer those questions out aloud. I just want you to answer those questions to yourself. And then when I ask the last questions, well, after I ask the last question, I then will ask you, is anyone disqualified under the law? And if you think that you may be disqualified under law based on the way you answered one or more of the questions, then I will ask that if you think that you may be disqualified under the law, please raise your right hand. And then we will ask you to come up before the bench so that we could discuss the matter more privately. And when I use the term more privately, what I'm talking about is we are currently airing on YouTube. We'll turn the YouTube off. We'll turn this microphone off. And then we have this noise sound device that we will play during our discussion. Okay. So again, I will ask a series of questions. I do not want you to answer those questions out loud. Just answer those questions to yourself. First question. Except for failure to register, are you a qualified voter in this county and in the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Sir? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, this next question, I usually pause and explain to the jurors that by law, I'm required to ask this question. I'm not trying to pry into your personal affairs. I'm just carrying out my duty as a judge. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay. We have juror number 4. Okay. And juror number 19. Okay. Is there anyone else on the panel that, raised their hands? Okay, let the record reflect that no one else on the panel raised their hand at this time. All members of the jury are qualified. Now I must move on to exemptions. I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just continue to be seated. Now, I will ask these questions in the same manner that I asked the previous questions. That is, I will ask a series of questions, and then at the end, when I ask the last questions, or after I ask the last questions, I will ask if there's anyone who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance in an institution of higher education? Are you a person who is employed as an officer, or are you an employee of the Senate, the House of Representatives, or any department, mission, board, office, or other agency in the legislative branch of state government? Have you served as a petit juror in the county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? Are you a member of the United States military forces, serving on active duty and deployed to a location away from your home station and out of Jefferson County? Now, if that was the last question, is there anyone on the panel who will be claiming an exemption? If you will be claiming an exemption, please raise your right hand. Okay, we have juror number 20. You can come forward. Okay, anyone else would like to claim an exemption? Let the record reflect that no one else is claiming an exemption. We will now move to excuses. And under excuses, I will not ask a series of questions. I will make 3 statements. And after I make those statements, if you'd like to claim an excuse based on any one of these statements, just please raise your hand and then we would ask that you will come before the court one at a time. All right. A juror may be excused or for an observance of a religious holiday upon completing the affidavit as required by the Texas Code of Criminal Procedures, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who will be exercising an excuse? Okay. No one else on the panel is exercising an excuse. No one is claiming an exemptions. No one else is claiming an exemption. And at this time, all the remaining jurors are qualified to serve. The time now is 3:07 p.m. on today's date of May 5th, 2025. And the court is in session and calls number M325-296. The case is styled the state of Texas versus Holgate Board Gonzalez. Mr. Gonzalez is present in court with his attorney Dustin Galmore. The state is present and represented by Assistant District Attorneys, Attorney Haley Simmons, Attorney Andrew Hubel, and Attorney Shane Hilton. The court reporter in this case is Miss Ada Christie. She's sitting to my left. She will be taking down everything that's being said, so speak up when you are answering or asking questions. The bailiff is Miss Brenda Mosby. You met her earlier. The defendant stands charged by information with the offense of driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. And what I mean by more privately, we'll turn off YouTube, the microphone, and we'll put on the noise sound device. State, are you ready to proceed? Defense, are you ready to proceed?
Great, Judge.
Okay, each side will have 30 minutes unless you need some additional time. You can just let the court know. At this time, Ms. Simmons, the panel is yours.
Thank you, Judge. Good afternoon, everybody. I'm gonna grab my clicker over here real quick. How are y'all today? The standard has the orange one, but show of hands, who's happy to be here? Oh, thank you. Let me ask an inverse since my big here. Who's not happy to be here? Okay, do you remember 19? Everybody just kind of mutual showed up because you got that summons in the mail. Did any of y'all look at that summons and just say, wow, just my luck? You did? That's fair. I've been summoned twice in the past 2 months. So I'm kidding. I understand luck. So again, my name's Haley Simmons. I represent the state of Texas and the people of Jefferson County. So the question, does anybody know me? And I know I hear you. Does anybody know my colleague here, Andrew Hubel? What about my fellow colleague Shane Hilton? What about defense Dustin Yalmar?
That's all right, say hi earlier, I missed that part, I think.
Does anybody here know the defendant, Mr. Jorge Gonzalez? What about the judge himself? All right, so you all know each other, anybody?
I'm from Louisiana, I don't know none of y'all.
You just kind of showed up, right? You're here. Okay, so I'm gonna move forward. I promise not to take too much of y'all's time. I know we got a little bit of a late start for that. I apologize. We had a few matters to take care of beforehand. But, oh, let me get this talk over word real quick, guys. So we are here today on a driving while intoxicated case. How many of y'all have heard of this offense before, show of hands? We're all pretty much familiar with driving while intoxicated? Everybody, okay. So what this is under Texas Penal Code, section 4904, a person commits an offense if the person is intoxicating while operating a motor vehicle in a public place. Does that seem straightforward? I'm gonna kind of dive into a little bit of the legalese with that, but I'm gonna move quickly, like I said. So intoxicated, I know this is small, and I'll try to read it out if anybody's having trouble seeing. It's broken down into 3 parts, and I know you're probably wondering why. Would it be a surprise to you if I told you there was 3 definitions for intoxication? Sure, number 4, you say no.
No, we're not these.
Not a surprise? Okay. I'm gonna kind of go down, I'm gonna pick on you a little bit, okay? So we have not having the normal use of mental faculties by reason of the introduction of alcohol. Not having the normal use of physical faculties by the introduction of alcohol. And this could be of any other substance as well. Or having an alcohol concentration of 0.08 or higher. Why would there be 3 definitions? I'll probably ask this question again later. I'm gonna drill it in there.
Yes.
What's that, Aaron?
Yeah, approach the bench.
Okay.
Yeah, you may proceed.
Okay, so again, juror number 4, I'm gonna pick on you again, we're going back to this, why would we have 3 definitions of intoxication?
Because, there are various ways to become intoxicated, not necessarily by alcohol. And what others get in mind,
The state of mind,
whether they're able to make it.
so when you say decisions, are you kind of referring to the loss of mental faculties there?
Yes.
Good. I'm gonna drill in with my really corny reference here, Revenge of the Nerds. Anybody heard of Revenge of the Nerds? Kind of late 80s? No? Sure, is it your number 10? Okay, well, you're gonna be Louis and Ogre today, okay? We're gonna talk about them. I'm gonna try to pick on everybody today. If you don't feel comfortable, just let me know. That's completely fine. So here I have Louis. You can see he's a little bit scrawny. We have Ogre, he's a bigger guy. Let's focus on Louis though. I'm gonna read it out loud. I know it's small. He weighs 145 pounds. He's never had a drop of alcohol until his wedding day. Had 2 glasses of champagne. His speech is slurred. Poured ballads. He's making inappropriate comments to the guests. But his blood alcohol content is under 0.08. Now remember those 3 definitions we talked about. Okay, everybody kind of got a good idea of where Louis is at? Ogre. He weighs 250 pounds. He is the champion drinker. He's been drinking since he started shaving at the ripe age of 16. Drinks 2 to 3 pitchers by himself. High tolerance. Normal use of mental and physical faculties. He's walking fine. He's talking fine. His blood alcohol content is over 0.08. Is everybody seeing any differences? Are we picking up on differences here? Juror number one, what kind of differences are you picking up between Lewis and Ogre?
Lewis has a low tolerance and doesn't need to be at 0.08 to lose.
So Lewis has mental and physical faculties, the introduction of a substance or alcohol. Does everybody agree with that? Some might call it, I think a couple weeks ago, Juror said he's a lightweight. Would y'all agree with that? Okay, what about Ogre, juror number two? What's Ogre looking like to you? A seasoned drinker. Okay, everybody else agree with that? No? Juror number 17, I'm gonna ask y'all to speak up, I'm sorry, it's not me picking on you, it's just so our lovely court reporter here can hear you. Why is it you say no?
You say you've been drinking since the age of 17.
Right, he's a seasoned drinker, juror number two said,
Season, that's daily. Shouldn't be.
he's a champion drinker, right?
Yeah.
He wakes up and he grabs his pitcher and he's ready to go. Do you think he's intoxicated though?
Yes.
Yes. Do you think Lewis is intoxicated as well, even though his blood alcohol content is lower than 0.08?
It's an up and down deal.
Why is it an up and
Because
down?
he's not a constant drinker, and a constant drinker could have one beer and they drunk like a. Not like.
Like a lightweight, right? Does anybody else feel like Luis might be kind of up and down on intoxication? Or does everybody see that maybe a weight loss and mental and physical faculties could be a sign of intoxication, or those definitions we talked about? Who here, show of hands, believes? Here, let's go to this. Is Luis or Ogre intoxicated under Texas law?
Objection, Judge, I'm gonna have to object. It's a commitment question based on facts that were given.
You want me to respond?
Yes.
I'm asking to their opinion as to the questions given. Not a commitment, I'm asking to the juror's opinion so I can understand.
But still, at least Louis, as far as Luis, there's no evidence he's above 0.08. There's facts that were given. It's a commitment question asking if the jury believes he was intoxicated, which is a legal term for the law.
Well, okay, objection sustained.
Skip through that, guys, let's talk about something else then. I've got three definitions I talked to you about, the loss of normal faculties in terms of physical and the loss of mental physical faculties. Both of those combined, some people like to put them two and two, that's fine. And then we have the blood alcohol concentration of greater than 0.08. Now, as I'm sitting right here, I have a burden today. My burden's gonna stay with me all week as we go through this problem. I don't say all week, I made a good report for you guys. How many should I have to prove? Of the three definitions, juror number 5. I know, I'm picking on everybody. I'm going down the way, I'm sorry.
How many should you have?
How many of those three definitions should I have to prove to show that the defendant is intoxicated? And like I said, we're breaking them down. We have the loss of normal mental faculties. We have the loss of normal physical faculties by introduction of alcohol or some other substance. And then that third one, a blood alcohol concentration of greater than 0.08.
One out of the three.
Okay, who all agrees with that? Show of hands, raise them high, raise them proudly. There's a lot of people not raising their hands. Okay, let's ask this differently and keep them raised for me. Raise your hand if you feel I have to prove more than one. Okay, juror number 1. Can you mark these down for me? Juror number 1, juror number 6, juror number 7, juror number 8. Back row, we have juror number 17 and juror number 19. Did you have your hand raised? Okay, I'm sorry, I'm short. I'm trying to see over everybody, but the heels don't help me all the time. Okay. Would it be a surprise to you that I only have to prove one? For those that raised their hand just now. What's that?
It's that one.
It's an or?
Well, I think everything, your definition said or this or this or this.
That's absolutely correct. Is there anyone here that would hold me to a higher burden and require me to prove more than one? For those that raise their hand, would anybody require me to prove more than one? Juror number 7, I don't know if I lost you here. You're kind of staring at it like you want to say yes. Would you require me to prove more than just one?
Yeah, right, yeah,
You would require it?
yeah.
Okay, even if my burden states that I only have to prove one. For your personal, no, there's no wrong answer, guys. Board dire means simply to speak the truth. I'm not picking on you, I'm not bullying you, we just want to.
I mean,
me, everybody acts different, you know, I mean, if somebody's got a speech impediment or somebody's not acting right, I mean, I think the whole mental thing, a lot of factors in that, I think, you know, somebody's not right in the head or something. I just don't see how the whole mental thing works,
So you're saying if there were a possible medical condition,
maybe, yeah,
that's why you would require me to a higher burden?
probably so, yeah.
Would anybody else require me or hold me to a higher burden? Does anyone else agree with your number 7? And I'm gonna get your name. Mr. Wallace?
Yep.
Does anyone else here agree with Mr. Wallace? No wrong answers. We're here to speak the truth, that's all. It makes sense, or you saying with your 7? Okay, you say it makes sense, but would you require that of me?
This is depend on the circumstance.
What's that?
That's a quick question.
A quick question or a trick question?
Question.
I'm not tricking anybody. I'm being straightforward. Y'all can be honest with me.
You're right. There's a
Okay.
problem.
Well, let's ask this. Let's kind of change it up. Would y'all be able to look at the facts before you and come to a conclusion based on the evidence that's presented if you're selected as a juror in this case? And assess, and if you found that I just proved one, would y'all be able to believe that verdict? Your number 7, you still seem kind of iffy. You want to talk about that separately? You still gonna require me to that one, or that regular one?
I'm not gonna say it like that, I mean, if it's the law, it's the law,
Okay, so you'd be able to follow the law.
yeah.
Everybody agree? I know, there's a lot of repetitiveness, I'm sorry, guys, we're just trying to make sure everybody understands, when we skip past this. Usually, unlike Mike, who's excited to be here and ask question, I get a lot of hands right here. Who here has ever been around someone who was intoxicated? Show of hands. Is everybody raising their hand? Turn over 19 as well, okay. Alright, alright. How did you know, or what kind of signs did you see that showed that they were intoxicated?
Speech.
Speech, okay. What is it about their speech that might show signs of intoxication? Slur. Everybody agree with that? Okay, number 7, I'm picked on you, number 6. What about you? Yeah, you raised your hand that you've been around someone intoxicated before. What kind of signs or indicators did you see that might include you in on that?
Short-term memory loss, inability to speak clearly and properly, inability to walk in a straight line without wavering.
Okay. So you said you knew how they were normally, so you kind of knew their tolerance. Does everybody understand that there's different levels of tolerance? But there can still be indicators of intoxication? Do y'all understand that? Okay. You, is it Mr. Blue? You went down the whole list for me, you did great right there, so thank you. Everybody agree with juror number 6, Mr. Blue, in terms of what are some signs of intoxication? Okay. I'm gonna ask a little bit of a personal question here. You're more than welcome to tell me if you don't want to talk about it in the presence of your personal or your fellow jurors here today. That's completely fine. But who here knows someone who has been arrested for DWI? Okay. 1 second, guys. I walk around when I talk, so I need to get back to my marker. Keep your hands raised for me. Juror number 1, 2, 3, 4, 7. You raise your hand back there, 14. Okay.
17.
Thank you for helping me there. Okay. Like I said, I try to see over sometimes, but I don't quite get there. All right. Knowing that, and you know you're here for DWI, would that affect your ability to be fair and impartial if you're selected as a juror on this case?
No.
It would not?
It would not.
Okay, what about juror number 1, 2, and 3? It would not affect your ability to be fair and impartial. Juror number 1, I saw the shrug there.
I don't know, I think that I can be impartial, I mean, I have personal feelings about it, but,
Okay, is that something you want to talk to outside the presence of everybody? We can call you up independently, that's completely fine.
I mean, it's okay, I just have personal issues with DWI.
Okay.
Not with me personally, but family.
Okay. I'm gonna ask a little bit more very personal questions, so we get more personal again. You're welcome to talk to me outside the present. Does anybody here know somebody who's been hurt, injured, or worse? Okay. Juror number 7. Shook your head very impressively. So juror number 1, juror number 3, 4, 6, 7. I saw a hand raised here. Juror number 10, Mr. Roundtree. Okay, let me ask y'all this. Just focusing if you're selected as a juror on this case, knowing that you have been through something such as this, or an intoxicated driver, someone who has been hurt, injured, worse, would that affect your ability to be fair and impartial in this case?
It would not.
It would not. Number seven,
Maybe.
possibly. Number three. Let me ask you this, your number three, it's Ms. Parker. I try to get y'all by the names, I'm sorry, the numbers are so easily accessible to me, but, would it be more personal? Here, Ms. Harper, do you want to discuss that outside of presence, or are you comfortable discussing it now?
My mother since passed away 5.5 years ago, but when she was 13, a drunk driver hit him head on, and my mother went through the windshield and had to spend the rest of her life scarred when she was 13.
I'm so
So,
sorry.
and then I've had like some classmates that have been, this wasn't as close to me, but some classmates have been maimed because of intoxicated drivers.
How recent was that in terms of your classmates? Is that
I
recent?
mean, I've been out of high school for 30 years, but it was like a couple of years after when so we were like, what, 18, 19, 20?
Well, again, I'm sorry to hear that. My apologies. Now, knowing that, and knowing that if you're selected for a juror in this case, you would be sitting and observing and driving while intoxicated class, would you be able to separate the facts from your mother and what had happened to her, and pay attention to just the facts presented before you? And be
I
fair.
wouldn't be able to be impartial, depending on the details, just because some circumstances in my life, over the last few months, it might be some triggers, not of alcohol, but just some triggers.
Okay, I understand that. So let me ask you this, you said you could be impartial, but could you be fair? You could. Juror number one, knowing that, and just kind of the same question we're gonna ask you that I didn't right here, but would you be able to be fair and impartial and just pay close attention to the facts before us? I know there was other hands raised right here, juror number four, you said you could. Juror number seven, you said you could, and Mr. Roundtree, would you be able to be fair and impartial? All right. Again, I'm sorry that each and every one of you have had to go through that. I don't like bringing up the personal issues. But thank y'all for being honest with me and talking to me, okay? By show of hands, this is kind of a personal opinion as to this. Who here feels that it's important that the state prosecute these type of cases? Number 8, you're just kind of here?
Yeah.
Okay. You're number 19, just kind of here as well? Okay. Let me ask you this, everybody that's raised your hand. Why? Why is it important that we prosecute these type of cases? Anybody?
It's not, quite a few across the front that have been affected by it. So it is going to continue to affect people who don't work as a group, society.
So when you say it's gonna, you gotta continue to work, you're talking about deterring, right? Because if you hold people accountable for their actions, you're deterring future activity, right? Those two kind of go hand in hand, but you're just right. And kind of like you said, few people, must have raise their hands here. We're really focusing on public safety. Can we all agree to that? Deterrence, like you said, and accountability. Public safety, accountability, deterrence. Everybody agrees with that? Am I missing anything in here? Does anybody else feel there's another reason we should be prosecuting these cases? You're number 6, Mr. Blue.
Strength of the law, instead of put a law in place, and if you don't enforce it, then it has no strength, it has no meaning anymore. So in that regard, you don't prosecute cases and stand by the law.
So if we don't enforce the law, we're just letting people run around. Is that what you're saying? And you guys say which? Everybody agree with that? We want to stop it from happening. We want to put a stop to it. Everybody feels that way? All right. Anybody can answer these questions. Ask them to participate with me. There's not a lot of you here, so work with me, okay? What kind of evidence would you like to see if you're selected as a juror on this case? Anybody going once, going twice?
Video,
Okay. I'm sorry. Was that
lab evidence.
lab evidence? Okay. Anybody else? Eyewitness testimony? That's right. Testimony is evidence. So you want to see maybe the body worn camera and car video? Scientific evidence, blood test, breath test. Let me ask you this, focusing on blood test and breath test. Would anybody require me show one over the other? Let's say a breath test was shown as the scientific evidence. Would anybody not be able to use that as evidence, or would they require me to have one? Is everybody okay with either or?
Brett says, you know, I'm in the paint, so a lot of my equipment has to be tested,
Okay,
you know, and I'm not saying that every one of them are, but, you know, the breathalyzers sometimes, you know, I mean, are they calibrated? I mean, I don't know, like, I don't know if they're calibrated all the time, what if it's faulty? Like, I think the blood is more better, but I mean, the breath test, I mean, I don't know.
so you said the blood is better in your eyes.
Yes.
Would you require me to show blood only rather than breath?
No, I mean, not a, the breathalyzer test, the rest of the test was took.
Okay, so if the breathalyzer was taken, you would still be able to look at that.
Yeah.
Does everybody feel that way as well? Is there anybody that would require one or the other?
Taking within the totality of the, evidence.
Okay, so looking at the totality of the circumstances, all of the evidence I present to you, you'd be able to look at everything and come to a conclusion, regardless of it being blood or breath.
Correct.
And determining the blood alcohol concentration. Are we all on level with that? On par with that? Okay. Types of witnesses, we have eyewitnesses, police officers, experts. Kind of want to dig into this one just a little bit. So what we mean by that is if we have witnesses coming in testimony, and like I said, testimony is evidence, they're gonna sit right here. I'm gonna ask questions, I'm sure the defense counsel is gonna ask questions. What they answer is going to be evidence for you to hear. Not my questions, but their answers. Knowing that, if you have an officer on the stand, would anybody give them a higher level of credibility? If an officer were to take the stand, would anybody hold them to a higher burden or find they are more credible than just a regular eyewitness or lay witness? Would anybody say their level of credibility is below that of an eyewitness? So it sounds like we're all on board that each witness, regardless of who they are, is gonna take that stand and they're all gonna start with that same level of credibility. Good, I like to see that. Absolutely correct. After that, whenever they take the stand, if we start with that same level, the credibility is for yours, so you determine. But we all agree we can start with that same level. Everybody? All right, so we talked about this. I'll skip past that real quick. Blood alcohol content or concentration. So when we have someone arrested for suspicion of DWI, the person is offered an opportunity to provide a breath or blood sample. Is everybody familiar with that or aware of that? They're given the opportunity. However, a refusal to provide a sample is not a constitutional right and has consequences. Anybody tell me why refusal might show that or might have consequences?
They're trying to get, thinking that you're gonna get away with something and you don't do that.
Necessarily. I'm gonna skip past that.
I'm gonna have to object. Judge, I believe that's an improper, can you turn it back? I believe it's an improper statement. That a person does not have a constitutional right to refuse, because a person does have a constitutional right to refuse. And if they do, the government has a right to seek a warrant in that scenario. But a person does have a constitutional right to refuse a search without a warrant being present.
Your Honor, if I may, it's the implied consent law.
Objection overruled. You may proceed.
So knowing that, the implied consent, when we all get a driver's license, what are we doing? Blindly consenting that we're gonna make or abide by the rules of the law, right? Traffic laws. We're not gonna run stop signs, we're not gonna run red lights. Everybody understands that, right? And that's because driving is a privilege, it's not a right. Does everybody understand that? Does everybody agree with that? Okay. We're gonna kind of move on, we're switching gears here. The burden is mine, and the burden is mine entirely. And what I mean by that is the state has the burden to prove this case. But that doesn't mean the defendant does not have rights, he absolutely does. But what he does not have is a burden, all on me. Defendant has a right to subpoena powers, he has a right to discovery, he has a right to trial, which is why we're here today. He has the right not to testify. Want to key on that one real quick? Would anybody here hold against him, the defendant, if he chose not to testify? Everybody's fine with that? Good. And he has the right to defenses. Presumption of innocence, everybody has it. Again, going back to my burden, beyond a reasonable doubt. As a defendant sitting here right now, would y'all be able to determine if he's guilty or not guilty? Anybody? Anybody would say he's not guilty? Anybody would say he's guilty? What does the presumption of innocence mean to you? Mr. Blanchard? I know you're waiting for me, weren't you? Like you said, you're just here. Presumption of innocence. And is it until proven guilty or unless? Unless. Makes a difference, doesn't it, when you say it out loud?
Yeah.
You say it out loud, y'all hear that difference there? Innocent until proven guilty? It's a final answer. And it's innocent unless. And that unless is there is because I have a burden. That's the burden you're gonna have to hold me to throughout this entirety of the trial, should you be selected. So let's get into reasonable doubt. Does anybody here think I have a definition to give you? Oh. Number 4, you know what? You're my go-to right here. I'm picking on you. This is a personal vendetta. Is it gonna come as a shock to you that I cannot give any definition? No? Good. I know I'm a lawyer, but I don't have all the answers, and some of them I just can't give you. Okay, that's wonderful. So Texas law requires I need my case beyond a reasonable doubt. It doesn't require that I give you a definition. That's because there is not one. What I can tell you is it's not beyond all doubt. If it was beyond all doubt, it's odds are you probably saw it, right? You saw it happen. And if you saw it happen, you'd be coming in to testify, you probably wouldn't have received a jury summons, you would have received a subpoena. Does everybody understand that? It's not beyond a shadow of a doubt. I don't know if some of you watch Law and Order and all those other law shows. We're gonna put that behind us, and we're gonna check that stuff out at the door. This is completely different. And it's not beyond an unreasonable doubt. It is beyond a reasonable doubt. The only thing I can tell you, juror number 4, is you'll know it when you see it. Okay? And that goes for everybody. Does everybody understand that I can't give a definition? Not even defense counsel can get up here and give you the definition. So I promise I'm wrapping up here. Here's the jury's duties. Cite the facts, apply the facts to the law, and follow the law. Knowing everything you've heard from me here today, is there anybody that feels that they cannot follow the law? I know that sounds like I'm coming after you, question, I promise it's not. We really just want to make sure we have the best jurors for this case. Does anybody here feel like they cannot follow the law? Does everybody here feel that they can be fair and impartial in a driving while intoxicated case? Is there anyone who feels they cannot sit in judgment of another for maybe religious or personal reasons? Is there anyone here that feels like maybe they cannot physically sit throughout the entirety of the jury? Juror number 19, okay. Do you want me to bring you independently for that later? Okay. You said physically you can't.
I'm ready to go now.
Okay. I understand. Now, when you say you're ready to go, let me ask you this. Knowing that well, I don't think defense counsel or myself can really say how long this trial will go. We hope it'll be quick, right? But with that, would you be able to pay close attention to everything before you knowing you don't want to be here? Would you be able to give it your undivided attention? Like I said, no wrong answers. Okay. So you would not be able to give the case your undivided attention. Does anybody else feel that way? No wrong answers, no hard feelings. Juror number 8, okay? You would not be able to give this case your undivided attention? Okay. And that's completely fine, guys. I'm not mad at you. Defense counsel's not mad at you. We really just want to know your best fit. Anybody else? Going once, going twice? The last time I get to talk to you. Okay. Well, thank y'all for listening babble for about 30 minutes. I'm gonna go ahead and pass the torch to the defense counsel here. If you're selected for a jury, I look forward to presenting this case to you.
Mr. Galmore?
Oh, yeah.
Mr. Galmore, you may proceed.
Thank you, Judge. Appreciate it. Good afternoon, everybody. Ms. Simmons has already done a lot of my material, so I'm gonna cut mine a little bit short. Let's see here. So one of the things I like to ask is who's excited to be here? I have a cute little baby up there. It's obviously really excited, but I'm not gonna bore you with that question. We already know who's excited to be here and who's not. So let me ask, some questions, just kind of general questions. If someone has made an allegation, okay, in this case, it's a DWI, could be an assault. Why are we here? If someone's made an allegation, why do we have a trial? Why are we here? Mr. West, is it Wallace? Oh, is it Wallace? Why are we here then? If someone's made an allegation that, Mr. Gonzalez is intoxicated or DWI, why are we here?
I give nobody, state the facts,
State the facts.
yeah, I
Okay.
mean, I guess how to find them guilty or not guilty.
Are officers always right?
No.
If this is an assault case, someone's accusing someone else of assaulting them, Mr. Farragut, are all assault accusers telling the truth?
Are all self-accusers from the truth?
So what's the purpose of the trial?
It's the truth.
It's an opportunity to hear the evidence, right? And see if it's right or wrong, right? Who thinks that's a true statement or has never happened? Innocent and behind bars. Do you think anyone has ever gone to prison that was innocent?
Yeah.
How does that happen? If there was a trial, right? Then how does an innocent person go to prison
With the trial,
with a trial?
evidence wasn't right or. Well,
I heard, I'm thinking her name, sorry, Miss Harrison. What did you say? You must have been funny.
I said pool,
Fool?
pool, you got pool.
Oh, got fool, okay. Hey, can jurors get it wrong sometimes?
Yes.
yeah.
Okay. So the reason I point that out is there's things in place that help stop that from happening. Okay, the state talked about the presumption of innocence, right? So she asked everyone who would think the defendant is not guilty right now, right? If the defendant in every trial is presumed to be innocent, and we haven't started the trial, there's been no evidence. If you voted right now, Mr. Roundtree, how do you have to vote? Not guilty, right? There's been no evidence to prove he's guilty, right? Does everyone see what I'm saying there? Everyone is presumed to be innocent. He is presumed to be innocent right now. And unless the government shows you plenty of evidence to convince you beyond reasonable doubt he's not guilty, well, then he's not guilty, right? Does that make sense? The presumption of innocence, this is an example of sort of how it works there, but police, they're operating under suspicion or what's called probable cause is a legal standard, but they're not deciding beyond reasonable doubt out on the street, right? Everyone understand that? Probably be a tough time to make those kinds of calls, right? Everyone understand it'd be better for an officer to investigate and then bring the evidence and neutral people later make that decision. Does that make sense? But if an allegation has been made, should it be proven? Yeah. And in criminal law, it should be proven beyond a reasonable doubt. In a DWI, there's probably going to be breath or a blood test, okay? So let's say there's a blood test and it's showing to be above a 0.08. This goes to the burden. The government admitted earlier, they have the burden to provide all the evidence, right? The defense doesn't have to show anything or prove anything. So if a blood test shows Larson to be above a 0.08, first of all, why are we having a jury trial? Miss Shannon, if there's a blood test showing someone's above a 0.8, why are we having a jury trial? Does anyone know? Why are we having a jury trial now? Should there be a rule that says if you fail the blood test, you're not entitled to a jury trial? You're shaking your head, Mr. Farragut. Why not?
Should there be one?
Yeah.
No, because everybody's entitled to due process.
Everybody's entitled to due process, okay? Well, if the state has the burden of proof, who has the burden to show that the blood test is correct?
The state.
The state. Are all tests correct?
No.
You mentioned earlier calibrating, breath, right? Why is that important?
If the machine is calibrated right, I mean,
If the machine's not calibrated right, then can you rely on the result? Miss Patterson, are you in medical?
I work at the health department.
Working in the health department. Was there a nurse in here? I thought there may have been a nurse in here. It may have been you I was just thinking about. Do you ever deal with medical tests?
Yeah.
First of all, are all medical tests 100% accurate? Okay, and what could cause a medical test to not be accurate?
A lot of things, even like the way you collected, the way you handle different things. And a lot of times we do blood tests at work, and so, if you didn't clean the machine that's calibrating it correctly, that can mess it up too.
Okay, so are you saying the collection process could cause a problem or contamination, right? The machine itself may have contamination. And so in the medical field, y'all oftentimes will have to rerun medical tests because there may have been a problem. Is it important for the state to show that a test is accurate? Who would make, if the state didn't show anything other than just simply here's a result, who would put the burden on the defense to show that there was something wrong with it? Does the defense have to prove anything in a criminal trial? No. No, what does the defense have to prove? Nothing, right? So again, the question would be, if the government's gonna provide a test to you guys, a result, should the government have to show that it's reliable? Yeah. Okay. These are burdens of proof. You've heard a little bit about probable cause. Clear and convincing evidence is up there. It's, like what they may use to take kids away in a family court. And then a reasonable doubt and beyond a reasonable doubt up there. If you have a doubt about a case, it's probably reasonable, right? I mean, no one here is gonna think that aliens came down and sabotaged.
Yeah,
the case,
to
right?
object us to the misstatement of or the improper statement of law as far as 100% beyond all reasonable doubt as to why 100% is even on the screen.
Well, what percentage of beyond reasonable doubt do they have to be?
The state's not required to prove beyond all or beyond 100% reasonable doubt.
Actually, yes, Judge.
Beyond a reasonable doubt, not beyond all.
If if the juror is less than 100% sure beyond a reasonable doubt, then it would have to be a not guilty verdict. What percentage less than?
We are not able
100%.
to give a percentage.
There's no percentage that's required, it's just beyond a reasonable,
That's correct.
reasonable. It doesn't say beyond 20% of a reasonable doubt, 100% of a reasonable doubt. The law is beyond a reasonable doubt. Objection sustained, you may move on.
There's no standard definition to beyond reasonable doubt. But in federal court, there's a definition, and this is the definition that was given. Proof beyond a reasonable doubt is proof so convincing that you would be willing to rely and act on it without hesitation in the most important of your affairs. Okay. Do you have any gamblers in here? I'm not a gambler, I always lose. No gamblers. No one likes to gamble. All right, we have a game. I knew there was a gambler in here. What's your favorite game? What's your favorite game?
Blackjack.
Blackjack, okay. $1. Not a lot of money, right? Would you be willing to bet 50-50 on something for $1? You wouldn't put $1 down on 50-50 odds? Well, what are the odds of blackjack? That's not enough, okay. So you would be willing to put it on ground because, right, okay. Would you say that that's one of your most important affairs, the outcome of that $1 bet?
Yeah.
Okay. What about $100? Getting more important?
Keep going.
About half your life savings. Would that cause you some concern about the outcome if you put half your life savings on a bet? They wouldn't? Well, you have way more confidence than me.
I have 4 years of 7th grade kid, got my back.
Oh, well, there you go. Well, there you go. What about jail time? Not anymore? Would everyone agree that jail time is super serious, right? Okay, now this is a misdemeanor case. Yes, jail time's on the table. However, probation's also on the table. Not saying that a person would go to jail automatically if they're convicted of the case, but what about criminal records? I'm gonna go back to you, Ms. Patterson. Is a criminal record important in your career?
My career,
Yeah. How would it affect you if you had a criminal record?
definitely look back and look at all.
It'd be very important, right? So even if you didn't go to jail, but having a criminal record is important. Who, is there anyone here that thinks, criminal record is not important? 2025 with the internet, right? How long do criminal records last? Does anyone know?
As long
As long as the internet's up, right?
Like,
Some people think that criminal records go away in 7 years. I don't know where that comes from. I think maybe refineries don't always count it against you. Criminal records are forever. Ask some questions. So, Ms. Patterson, do you believe that we are mostly the products of our heredity and our environment? Or do you believe that the decisions people make determine their status in life? Everyone read that question. The question basically is, do you think that where we end up is based on our heredity and our environment and where we're born? Or do you think that it's 100% up to the decisions we made in life? And honestly, it could be somewhere, in the middle, but these are scale questions. Let's just say, if you believe 100% that your environment, your heredity, your parents make you who you are, it's a 1. But if you're 100% in control of your life and wherever you ended up was you're based on your own choices, that's a 7. Okay, 1 to 7. Let's just go through and see what people think. What do you think, Ms. Patterson?
based on the training that I got before work, I'm gonna say that it's probably closer to the environment, not necessarily hereditary, than it is even, the decisions you make. A lot of things are predetermined for you, and you can't, it's hard for people to get out of certain aspects of their life, even when they have all the resources there. It just is.
So sounds like you're closer to a 1. Would you say a 1, a 2, a 3?
Say a 2 or 3. but
Okay, okay. What about you? I have not called on you yet, Mr. Woodside. What about you, Mr. Woodside? What do you think?
I have to say number 7.
7. Okay. Ms. Harper.
You could go either way, but in my line of work, I would say probably 4.
Okay.
You can have the best environment and the best team, you can make the most powerful decisions, or it can be opposite. There's a combination.
Okay. What about you, Mr. Carter?
I'm sorry, but what is the scale again? 1 being.
So 1 would be that you believe that a person ends up in life based on their upbringing and their heredity and their environment. Or 7 would be, it's 100% your own decisions, not your heredity, not your upbringing.
Since we can't go 3.5, I'll go 4.
Okay? That's on purpose, by the way.
Yeah, I know.
No, 3.5. If you want to vote 3.5, I guess you could. What about you, Ms. Mingo? 5. Mr. Baloo?
6.
6. Mr. Wallace?
7.
7. Mr. Blanchard? 5. Ms. Shannon? And Mr. Roundtree? 2 more, right? No, 3 more. Mr. Perez?
5.
5. And Ms. Harrison?
4.
And Ms. Milton? Okay, fair enough. All right, now everyone see how it's done, I'm gonna ask you a different question. Are people's misfortunes often thrust upon them? Or are their misfortunes a result of mistakes that they make? So it's a little different. Are people's misfortunes often thrust upon them? Or, which would be a 1, or do you believe that people's misfortunes are a result of the mistakes that they make, which would be a 7? Let's just go down the row again.
I think it's middle line, I mean, people have both.
Mr. Woodside,
Say both, depending on the circumstances.
so maybe in the middle. Ms. Harper,
In the middle, because you can't always control what life throws at you, but you can maybe how you handle life. So I think it's in the middle.
okay, Mr. Farragut,
I'll go with that feet.
how much?
What's your three?
3, okay. Ms. Miga,
5.
5, you just like 5? Hey, you're number 5, I'll take that, there you go. Oh, Mr. Baloo,
If I have an issue with the word often.
often, okay. I understand that. Mr. Wallace,
Still 4.
okay. Mr. Blanchard, okay, Ms. Shannon. Mr. Roundtree.
5.
Mr. Perez,
5.
Ms. Harrison,
Between 3.5 and 4.
okay, and Ms. Mills.
Yeah.
Okay. Last one like this, I promise. Our destinies are each determined before we are born? Or do you believe that we all have free will, so each of us makes our own destiny? I'll go backwards this time, I'll let you think about it this time. Ms. Milton. 1 to 7 again, 1 destinies are each determined before we're born, and 7 would be, we all have free will and we all make our own destiny.
Yes, in the middle.
Okay. Ms. Harrison, 6. Mr. Perez,
6.
Mr. Roundtree,
7.
Ms. Shannon, Mr. Blanchard. Wow, 7. Mr. Blue.
7.
Ms. Hagan. Very good. 4. Harper,
6.
what's that? 4. And Ms. Paxton. Okay. Change gears a little, talk about children. When it comes to raising children, is it more important to have a child who is respectful or independent? Think about it a minute. More important to have a child that is respectful or independent? Everybody understand? There's no right or wrong answer. It's not scale 1 to 7, just whichever one you think is more important. Okay. If you had to pick which one would be more important. Okay, I like that, Ms. Harrison. Okay. All right, Ms. Milton,
I'll go with independent.
okay. In fact, just to save some time, who all thinks that it's more important for your child to be independent than it is to be respectful? Okay, so we have 1, 3, 6. Okay, so who thinks it's more important to be respectful then? Okay. Let's skip number 2 and let's go to number 3. Is it more important when raising a child for them to be well behaved or to be considerate? Well-behaved or considerate? Who all thinks it's more important for a child to be well-behaved? Yes. Okay. Okay, so 3, 5. Eight. Okay, 15 and 19, okay. Okay, and so everyone else has to raise their hand on this one. Who thinks it's more important for the child to be considerate? Okay, so 1, 2, 4, 6, 7. 1, 2, 4, 6, 7. Okay, and 10. Take it back. Okay. All right. Move on. Who agrees with this statement? Police should be allowed to arrest and question suspicious persons to determine whether they have been up to something illegal. Police should be allowed to arrest. That's the important word right there, arrest. They should be allowed to arrest and then question people who they believe have been up to something illegal. Okay, does anyone feel like, yeah, they should be able to arrest people or question them and see if they've been up to something wrong? Anyone feel that way? Okay, somebody feel not that way? Okay, Mr. Fogg, tell me what you feel. What do you think?
I disagree with that statement more,
Okay, and why?
because we have something called rights, they need reason for articulable suspicion, being there and acting funny, not reason for suspicion, enough. And just go around arresting people and then question them, or even go arresting and then question. You have to investigate, detain, then arrest.
Okay. Did everyone hear what Mr. Fogg said? Does anyone disagree? This has been asked, but I want to go over this a little bit more. I'm not going to spend as much time on it, but these are some common reasons why people do not feel comfortable being jurors on DWI cases. Usually there's, it's one type of cases that can cause that. It could be your own personal prior experience or family members' experience with drugs and alcohol. It could be, you, a friend or a family member were victims of DWI. It could be work or personal experiences. Sometimes nurses who work in ERs don't really want to deal with that kind of case. Thing is, there's no right or wrong answer, but I used to have a slide. It was really funny. It was Michael Vick. Everybody remember Michael Vick? He got in trouble for fighting dogs. And I don't know why I don't have it on my thing anymore, but it was a jury of dogs, cartoon dogs, and Michael Vick was on trial. Who thinks that it'd be fair for, dogs to be on the jury of a Michael Vick trial, right? So it's okay if you're not the perfect fit for a case. We all have different life experiences. And so I know that you had mentioned, Ms. Harper, you had personal experiences. And so I'm just going to go to you because you said that. Do you think that a DWI would be the right kind of case for you to be a jury on? Or is it possible, at least, that your prior personal experiences might influence you in some way, or at least make you not as close to fair as you could have been once they had that case?
Of course, I have a negative experience having my mother having gone through a windshield. But also my line of work, I give chances every day. It's a new chance when you walk in to my room, so I could be partial and fair because like his case doesn't have anything to do with my mother. But yet it would only have the similarity with DWI.
Okay. Anyone else? Anyone else have any kind of personal experiences or anything that say, you know what, this is just maybe not the right kind of case for me to sit as? Okay. If there's anything else that a person, well, first of all, let me ask this. Is there anyone that's got something to say that we just didn't ask? Sometimes there's something someone says, hey, I'm gonna wait for them to ask me this, and then we just never ask that question. Anyone? There's also an opportunity to talk to the judge, once we've ended this part about personal matters of any kind, not in front of everyone else. Does anyone have anything they would like to talk to the judge about? Okay. All right. I think that's all I have. The last thing is your job description. Determine if the state ruled
I'm gonna
out
object, Your
every
Honor.
reasonable doubt.
It's the statement of every reasonable doubt, it's beyond a reasonable doubt, not all.
If there is a reasonable doubt, then it is a reasonable doubt. Just like earlier, if it's 100% beyond a reasonable doubt. Can't be 90% not beyond reasonable doubt.
Can't give percentage.
Okay,
It's not
objection,
true. What's the case? What's the case?
objection sustained. Objection sustained. You may move on. Okay. Okay, ladies and gentlemen, we're gonna ask that you, go out into the hallway. There may be some follow-up questions that the lawyers may ask of some of you. And so if that happens, then we'll call you back into the courtroom. So at this time, the court is in recess. Everyone, please stand as the jury exits the courtroom. You can use either one of the doors to go out. Okay, you may exit.